inquire into this matter before this security of ownership can be taken away. Now, currently, it is being proposed that this power should be vested in the Chief Registrar, an administrative officer. And it is saying the Chief Registrar should be given this power to cancel a certificate of title that was obtained either through fraud, misrepresentation, or concealment of a material fact. It fundamentally shifts the power to determine the validity of certificate of title. And then when you look at the proposed section 57A, it is saying that this will be done to the satisfaction, or as the Chief Registrar would determine. It's making it very subjective. It is as the Chief Registrar determines. Then you are giving this administrative officer power to sit as an adjudicator and begin to inquire and to hear into a dispute and determine whether a person should have the property taken away from them or not. We have said the potential advantage is the administrative efficiency. It will take quicker time, it may be less costly, and it may also take less time than our courts take. Our courts are inundated with a lot of matters, so sometimes courts take time to dispose of matters. However, administrative efficiency cannot override the security of tenure that this title is afforded to a person who owns land. Due process should always be afforded and given to such a person. And so we are saying the challenges and disadvantages override any administrative efficiency that this process may give. We are also saying, what is the mischief that exists right now? That we should amend one provision of the entire Act. If we are talking about changes to the law, it should be comprehensive. We should talk about comprehensive law reforms or land reforms as opposed to a targeted amendment. What is it that the courts have failed to do, which should now vest in the office of the Chief Registrar? I am privileged, Chair, to sit at the Lands Tribunal. I hear and inquire into disputes. I have been privileged to see how power is abused in the Ministry of Lands. I have been privileged to hear and inquire into re-entries. Re-entries, land is taken away from a person who has defaulted on their lease conditions. The law provides that you give this person notice so that they come and give a response why the land should not be taken away from them. And you will find that we reverse these entries, whether at the Lands Tribunal or in the Superior Courts. In fact, Superior Courts have time and again reversed because there has not been due process that has been accorded to title holders. So we believe and we submit that this power should continue to be reposed in the courts to protect every citizen of this country to be accorded due process, Chair. We are also saying, when you look at, it's not talking about appeals. From the registrar, you go to the minister. From the minister, ultimately you end up with courts. You're just lengthening the process, which ordinarily should have been shortened. You're saying this should go to the minister. The minister is a policymaker. Administration of land is vested in the Commission of Lands. Why are we even appealing to an office that is not vested with power of land administration? So we're even delaying what is already a delay. Because ultimately, when the registrar makes a decision, if I'm dissatisfied, I go to the minister. When the minister makes a decision, I'm dissatisfied, I'll still go to court. What are we doing? Lengthening the process, which ordinarily a person could have already started at court. But you're saying, go to this, go to that. And then notices. As I said in re-entries, notices are hardly served. That's why there have been reversals. They can't even prove that a notice was served on a person before they took away that land. And this provision is already given default power to the registrar, chief registrar. that if I don't make representation within 30 days, the registrar should make such decision as he or she deems fit. Where will the proof of service be? In courts, I have to file an affidavit of service to show that I served. If I can't find you, I have to advertise. And I'll need to show the court that I did advertise in a daily tabloid to make these proceedings aware to you. We don't even have any provision for how this notice should be served. It's just saying, if 30 days is not, somebody doesn't make a response, then you take away the certificate of title. You can make that decision. So, Chair, we as LAZ are not supporting this bill in its entirety. There is also no provision for compensation, Chair. A person who is deprived of property should be entitled to adequate compensation. When we go to court, a court has powers to make such orders. A chief registrar here is just being empowered to cancel, and that ends there. So what right or what alternative is there to this person who will be deprived of this property? They can't even begin to claim from this chief registrar for compensation. It still goes back. This person will still have to go to court and complain, my land was taken away from me, but I wasn't compensated. We go to the same thing. The process will have to start. So we believe there is no mischief that needs to be cured at this point in time. I submit, Chair.
Thank you very much, LAZ. Okay, I can see the honorable members are actually itching to ask questions before they come in. I want to ask you a question as LAZ, because in your submission you keep on saying that the power to cancel the title deed will be given to the what? To the chief registrar, but you are not talking about the whole process where to end up to the High Court, and you are saying that the period for this appeal may take long, or we may elongate the whole process, but you're not talking about the time to appeal to the minister 14 days. You just hold on. You ask 3 questions, they will give you time to answer 3 questions. You're not talking about that. So I wanted you to talk about the time frame so that the Zambian out there can also understand the time when to appeal and how long it will take. Because the previous witness did indicate that he has been handling a case that has taken too long, 14 years in court. So what about a poor person? What about somebody who is in Shangombo, who cannot even manage to meet the legal fees? 14 years, you are just trekking to the Zambian court, High Court. 14 years, counsel. The second question I want to ask counsel, we have seen how crooked and how corrupt people have been, especially that Minister of Lands. Today they are able to issue titles on road reserve. They get fraudulent minutes from Lusaka City Council. They will manage to bypass all the system and get title on the road reserve. Are you telling me that the community should wait and take the matter to court, yet somebody has blocked the road and built on the road reserve and title is issued? Should we wait for 14 years for that act to be corrected? Honorable Sibuzingiri, you can come in.
Thank you, Chair. Thank you, LAZ. In your submission, in terms of advantages, you have indicated that these powers, if they are given to the registrar, it aims to bypass potentially lengthy and costly court processes. Secondly, ordinary citizens and administrative processes might be less daunting and expensive. Is this not what this government wants to cure? For my people right in Gwembe, ordinary citizens, who will not afford these costly legal expenses, they will be able to deal with the registrar. And the appeal process is very, very clear that if they are not satisfied with the registrar, they will go to the minister. If they are not, if the minister does not get a good job and they are not convinced, they will still end up in the court. Why should it be a situation where anybody who has a complaint to do with land, the ministry's answer will be go to court, when it can easily be done, like you have indicated in the advantages, and which is the cure that this government, because there are hordes and hordes of these cases and that are pending, and there are hordes and hordes of these cases that have been in court for so long. Meanwhile, everybody is stationary waiting for the court processes. This might take even 50 years. Don't you think this is a cure that this government wants to increase the efficiency of this cancellation of title?
Honorable Simbao.
Thank you, Chair. LAZ, I hear you when you say it's going to lengthen the process. But supposing this, because you said the registrar is simply like an administrator. Supposing this registrar, the qualifications are raised to that of maybe a equivalent to a high court judge, would you still not be comfortable with this? To be frank with you, like in my constituency in Luansha, 30% of the people that you find coming to my office are complaining of how they've gotten their land, how maybe council has ended up giving land to either an Indian or some foreigners, and they've been asked to go to court. Right now I've got a group of women who, when they were putting this pipe by Kafu, it passed through their land, and they've taken their land. And they've been asked, if you want, go to court. And they can't afford. These women are just completely helpless. And here is a law which is saying it gives them an opportunity to go to the registrar who can assist in that area. What's your comment?
Witness, you can answer those 4 questions.
I thank you, Chair and honorable members, for the questions that have been posed. You had spoken about the time that is being proposed, that it will take so much time. It is saying 30 days a person should respond. One thing you should realize is that it is not 30 days that is adequate for everyone. We have title holders who are Zambians who live in the diaspora. I don't even know if that notice is going to get to them today. And so if they don't respond in 30 days, what is going to happen to those people who can't come in 30 days? Yes, the time may look short, it may look convenient, but this is why we are saying the advantages we wrote, which we even, when we researched, we said these are the advantages that this would give. We are saying they still can't override the power for this to be reposed in the court. Yes, it's 30 days, then 14 days it goes to the minister. But what we are saying is that now we are creating a 3-tier process now. So the first tier is we go to the chief registrar. That's the start point. If the chief registrar cancels, the second tier is going to the minister. And the minister will determine in 14 days. Hopefully they'll be sticking to those timelines. We know how busy ministers can be. So if the minister doesn't decide in 14 days, what do? I still wait? I'll wait until the minister decides. So once that 14 days or whenever the minister gives, and I'm still dissatisfied, what happens? I still go to court. Which court will stake either the 14 years, or sometimes matters are disposed of. I'll speak of myself because I'm proud of the work that I'm doing. I work hard to ensure that I dispose of my matters as quickly as I can. But the fact is, Chair, as has rightly been said, we have a lot of cases that have spent years in court. We won't deny that there is the existence of those long cases. What we need to do is improve the system. we can't say that this ultimately is a cure, because this is not resolving the issue in its entirety. Unless these decisions will be to the satisfaction of every member whose title will be cancelled. And you see, we all have this alleged to property that we own. You can't wake up one day and you're told that your title is cancelled and you sit back. Of course, unless you knew that you really did get it through fraudulent means or through representation. But if it is title that was genuinely and honestly issued to you, you'll fight for it to the end of your breath. So no matter what happens, unless this process you're saying will cure everything, and whenever people's titles are cancelled, it will be to their satisfaction, then that will be a solution. But we know it will not be a solution. People will fight. And like I'm saying, unless it was really issued and they knew that they are not entitled to that property. But for every person who holds a property and has a title, they fight for it until the end. And then, Chair, it was also saying crooked people bypass the system and get title. That's why we have titles issued by Ministry of Lands that shouldn't have been issued. The question is, where are the present checks? So, when you give power to the registrar today, have you dealt with the crooks that are bypassing the system? No. We need to go back and deal with where the root is. If we don't take away this root, this seed that is causing titles to be issued which shouldn't have been issued, even with the registrar sitting with powers, we'll still continue having this being happened unless there are checks in place. So this title was issued by the same registrar who's cancelling it. Where was the registrar? Why didn't they verify? What system do they have in place to ensure that if something is coming from the council, it is properly checked? Or that if there is there are processes in the land system before a title is ultimately issued. What is the check at every stage? What are we supposed to be doing right now if people are bypassing the system? It's to ensure that we close the gaps, not to give power to the registrar. So that when we close these gaps, we'll know that the titles that would be issued would have genuinely been issued, Chair. When we come to qualifications, it still doesn't take away that this is an administrative officer who we are giving power to adjudicate. They're not adjudicators. You are giving them power to inquire into a right of somebody and take away that right to property. So whether they are of High Court qualification, Judge, Chair, I still believe that should not be the case. The Honorable Member for Luansha talked about a case. That doesn't even go to fraudulent title. It's somebody whose right of land is being infringed upon. What we need to be doing is sensitizing our people time and time again of their land rights. The problem in that case is that these people are not even aware of their land rights. That's why somebody can pass a pipe and suddenly say that the land is mine. This here, when in that situation, Chair, we're not even dealing to the fact that this title was issued either by misrepresentation, concealment of facts, or something of the sort. It's just an issue where how much are we telling our people where you come from? How much sensitization are you telling them? What rights are you educating them? Are you telling them about how they need to know about their land rights? Because if we don't tell them, how will they know? Thank you, Chair.
Thank you very much, Witness. I just have one burning question before Mr. Honorable Chalo, because we are running out of time. One burning question. There are other stakeholders who have submitted to this committee supporting this bill. What is your take as LAZ? Honorable Chalo.
Thank you, Chair. Thank you, LAZ, for your well-detailed presentation. You have indicated the advantages and disadvantages of this proposed bill. I think you have gone further to mention that there is no even provision of compensation. For example, this person reaches at the minister's level and maybe that decision is resolved there. but there is no any compensation attached to the same. So I wanted to find out from you as LAZ, with this situation, what is your proposal? Do you propose that this bill can be deferred to allow for broader consultation so that some of these issues which have been highlighted can be taken into account?